Good evening. Welcome to Left, Right and Centre. I'm Vishnu Shom. On the programme tonight, the Maharashtra Chief Minister Eknath Shinde will get to keep his job despite gaining from an illegal decision by the then governor, is what the Supreme Court has ruled. So, is this a moral victory for the Uddhav Thackeray camp? Mr. Thackeray had lost many of his party leaders who went on to tie up with the BJP and form the government, bringing down the MVA government in the state. However, on the key question of disqualification of the MLAs who are now in alliance with the BJP, the Supreme Court has said that it is up to the Speaker of the Assembly to decide, but that there must be a decision in a finite period of time. Next up on the show, I'll be joined by Mahen Kumar Siratan, the Minister of Financial Services and Good Governance of Mauritius, on his statements in his country's parliament on why he believes the allegations against alleged shell companies of the Adani Group are false and baseless. That's an important interview at a time when SEBI is probing the allegations here. Later on the show, another huge Supreme Court verdict. The Aam Aadmi Party's Raghav Chadha joins me after the Supreme Court rules that the state government and not the centre has the right over essential services in the national capital. In other words, the Lieutenant Governor cannot stall administration, nor can bureaucrats say that they don't report to elected MLAs. And finally, as you can see, it's a packed program today. His first interview after arriving in India, Eric Garcetti, the new US ambassador to India, speaks to my colleague Maha Siddiqui. That's coming up on this program as well. But first, let's look at that landmark Supreme Court order as far as Maharashtra is concerned. Priyanka Chaturvedi joins us now, the senior Shiv Sena leader. Thanks, Priyanka, very much for being with us. What exactly does this mean in terms of the entire disqualification procedure now? It's up to the Speaker, but ultimately it could go back to the Supreme Court as I understand it. Is this something that you're going to be pushing for very, very closely, that those MLAs have to be disqualified in a finite period of time?
Oh, absolutely. It is the responsibility of the Speaker, especially a Speaker who also has been elected unconstitutionally and illegally, if I go by what the Supreme Court has judged. Even the run-up to the floor test, which is termed as unconstitutional role by the governor, is categorically shows that this government is only running on the basis of wanting to be in power, but not having the moral right to be in power. Because election of the Speaker and even the trust vote that the Chief Minister has won on the basis of an illegal whip, issuing a whip to his 40 MLAs to vote in particular favor. So we are going to challenge the disqualification. And since the Supreme Court has said it comes in the purview of the Speaker, we will take this up. The second important thing that the Supreme Court has also gone on to mention is that the Election Commission cannot decide the legality of the symbol or the party name on the basis of legislative strength.
Right.
The most important decision that they've done is upheld the 10th schedule, which says the political party and its decision is above the legislative party, above the parliamentary party, and that cannot be denied. So I think this is a very historical judgment in terms of maintaining constitutional propriety as far as governance is concerned. And the way we saw BJP pulling down governments, this is one of them. So we may not have got the government back in power, because that was not really a case to fight. A case was.
But is that something you regret, Priyanka, that the Chief Minister at that stage, Mr. Thackeray, went and resigned, right? The Supreme Court today seemed to indicate that you may have had relief, you may have gained relief at that stage had he not done that.
No, so what is also proved by this is that he did not want to be part of the entire unconstitutionality that was prevailing at that point in time, which the Supreme Court has called illegal and unconstitutional. Right from declaring the legislative party leader as a Shiv Sena party leader and allowing them to vote, allowing them to select a chief whip, has actually been told by the Supreme Court that it was unconstitutional. So government, we may form the government, we may lose the governments can stay, the governments can be reconstituted, brought back through a judgment. That was not a case to fight. A case was how this entire unconstitutionality was going on, and he refused to be a part of this. He refused to want to go for a floor test on the basis of all the steps that were taken which went against the principles of
but you know, Priyanka, now
what anti-defection law.
Eknath Shinde, the Chief Minister, has interpreted this in exactly the opposite way. He has said, and I quote, "In a democracy, importance is given to the majority. Today's decision proves that the government that we formed, we did it legally and constitutionally." Those are his words.
I can only wish him good luck, because in the future, if this is his idea of interpreting court judgments, then I don't know how he interprets the entire governance of Maharashtra. And that is why perhaps Maharashtra is suffering. Right from industry stepping out of the state, to what we are seeing with the Barsoor refinery, to what we are seeing in terms of rising unemployment, to, the entire, whether it's the farmers, various sections of the state, absolutely rebelling against this government, just goes to show he has zero idea. He's just a puppet in the hands of the BJP. And today it's the BJP which stands exposed for all the immoral activities and illegal activities that they have been indulging in just for the quest of power. I think by stepping down and not going for a floor test, one thing that comes across clean is that Uddhav Thackeray did not want to be part of unconstitutional measures that were being taken to dislodge him. B, that it wasn't the perks of power that he was running after. It was just that he wanted to work for the people of Maharashtra. And that was unconstitutionally denied to him by the governor. And I really think the governor action should be taken against the governor. The governor cannot be let away by saying what he did was unconstitutional. There should be some action directed at the governor.
So the governor said that he is not a lawyer. The options which were given to him at that time were what he had, and so he acted. He said, I'm not a lawyer.
No, he's not a lawyer, but he clearly proved himself to be a politician.
No, but let's just look at the
behest of the central government.
But I want to talk about the role of the governor, because here's another quote from the Supreme Court. It is important. The governor did not have any objective material, and the exercise of discretion of the governor in this case was not in accordance with the law. In other words, the basis, one of the key points on the basis of which your government collapsed was the role of the governor. This is not just about Maharashtra, but I think it sends a message to other governors elsewhere as well.
Absolutely. And if you look at the judgment on the Delhi government versus the LG, also categorically shows how these figureheads are now misusing their positions, continue to be party political people, agenda driven people, carrying on with a political agenda that they believe that they have to carry out in any state that belongs to a whether it is West Bengal, whether it is Tamil Nadu, whether it is Telangana, Maharashtra. We've seen what has happened, and now the Supreme Court calling it unconstitutional. I really think till a precedent of punishing the governor, I hate to say it, does not happen, they will continue to misuse their role, and authority pissed out on them. Now he worked out of authority also and out of his domain also in pulling down a government. So the Supreme Court is saying we cannot get the government back, but all that happened was unconstitutional and illegal and immoral.
Sure. All right, Priyanka, thanks very much for being with us. We're joined now by Dr. Abhishek Manu Singhvi, who's been a key player, obviously, as a Congress leader, also as a lawyer who's been tracking this, very, very closely, the entire process of whether disqualification can take place, the circumstances in which the last government in Maharashtra fell. So bottom line, Dr. Singhvi, if you look at what has happened in the Supreme Court, would you agree that this is essentially that Eknath Shinde keeps his job and that there's a moral victory for Uddhav Thackeray?
First of all, the word only doesn't go with moral. It is certainly a moral victory. It is an ethical victory. It is a political victory. It is in a large measure, I would say 75% a legal victory which has been missed out. Now let me tell you why there are two facets. You are obviously talking about the glass 25 or 20% not filled. That is no status quo ante restored. But remember, every major issue was decided in our favor. Number one, the Speaker's decision recognizing an invalid whip is wrong. Secondly, the appointment of another whip is wrong. Thirdly, Uddhav Thackeray's whip is the correct one because he is the political party. Fourthly, the governor's decision to call a floor test is wrong and illegal. Now I ask myself the first question, Vishnu, in answer to your question. What is left after these four major findings?
Yeah.
You have no ethical, moral or political or even legal right to do because they are all four legal findings. But now let me come to your other question. There is another important sentence in the judgment that the disqualification petitions pending now should be decided
exactly
within a reasonable period, quote unquote.
Yes, exactly.
Now, according to me, if you are the speaker, the new speaker, the current speaker, and my disqualification petition against XYZ is pending, and if you are bona fide and you take it up tomorrow, 1 week later, 2 weeks later, there is no decision you can arrive at except disqualify that XYZ. Why do I say that? because the disqualification petition, Vishnu, is based on a violation of the whip, which has now been held to be legal and valid. Till now there was some confusion, right?
Right.
Now, if you know, Vishnu, without being a lawyer, you don't need to be a lawyer to know that. If you violate a whip, which is a whip of a political party, which has now been held to be the only recognized whip in the system, then you are on the face of it disqualified. There is no adjudication required. Now, I have therefore no doubt, as I predicted today in my press conferences, that the game now will be played, will be delay, delay and delay. The speaker will not take it up. The speaker will decide not to decide. It is going to be very difficult for the speaker to give a wrong decision. Either way, there will be a challenge. If you give a wrong decision or if you don't decide. And in that challenge, we have a chance of succeeding, because with the whip now being clarified, there is no way in which this disqualification should not follow. So it's a much bigger victory than you think. It's more than 50%. It's more than 75%.
So, Dr. Singhvi, I just wanted to talk a little bit about the role of the governor, because the Supreme Court said that he didn't have any objective material and that his exercise of discretion, that's obviously a key part of what a governor is authorized to do, was not in accordance with law. How significant is this in terms of, a remark or a comment on the functioning of the governor at the time?
Of course it is stinging. But, as you know, that thick-skinned people, the sting does not register. I have no doubt that this kind of high-handedness will be repeated. I'll tell you now, there's another facet to this. What did the governor do? The governor directed a floor test. Now I know that Mr. Thackeray resigned before the floor test. But what was the decision of the governor for which he had no objective material? The direction to have a floor test was that decision.
Right.
That decision has been declared to be illegal. Namely, the foundation, the floor test, the governor had no material to direct a floor test.
Right.
If that foundation goes, even the fact that Uddhav Thackeray did not participate becomes largely meaningless. But we understand and we accept that he's not been restored. But the very foundation of the entire exercise is gone.
So,
therefore, the crux lies now, Vishnu, in a fair, quick decision by the speaker. A, if that decision is wrong, it will be challenged fast and promptly. B, if there is no decision or a decision to delay a decision, then also it will be challenged. So they are in a fix.
But Dr. Singhvi, just a clarification, the speaker will decide now on disqualification until a court does, right, with a larger panel of judges. So if when you mention or when you say that, look, if the speaker does not act in a finite period of time, you're going to go back to court, would that be before a larger bench of judges?
Not larger panel, it will be decided by judges. It will go, what the court has said today is that they do not decide disqualification themselves in the first instance. The first person to decide it has to be the speaker. But the point is different. I am saying normally there can be no valid reason displayed in the order of the speaker as to how he decides to dismiss the disqualification. Once the whip has been held to be valid as issued by Uddhav Thackeray or his group, then disqualification must follow.
Okay. Was it in hindsight?
And therefore the decision of a speaker not doing what I am saying would be so patently contrary. Of course, he's entitled to give it because he's buying time.
But in hindsight, was it a mistake?
And there'll be very good chance of success against that in the court.
Was the, in hindsight, was it a mistake for Uddhav Thackeray to have stepped down? Because it seemed the court seemed to suggest today that had he approached the court at that time, he would have gained relief.
Clearly, wisdom by hindsight is always 20/20. Sure. And we don't know the reason, etc. There is no need to go to the reason. Yes, had he not done it, perhaps, these speculative issues would not have arisen. But the point of the matter is that today there is a resounding victory in favor of the so-called Uddhav Thackeray faction or group. Today, anybody with shame, with less than thick-skinned in politics, with fairness, look at every institution, Vishnu, just for a minute. The highest institutions of the state are what? The governor, the speaker, and a central government which is pulling the strings.
Right.
Clearly all this is happening by the central government acting as the master puppeteer for persons in the state who are acting as stooges or puppets.
Yeah.
That is really the takeaway.
Yeah.
Does it show the ruling BJP in a good light? It shows it in a very, very poor light.
You know, Eknath Shinde has said, and his interpretation of this is completely different. He says in democracy, importance is given to the majority, and in his interpretation, today's decision proves that the government that he formed was done legally and constitutionally. So he sees this judgment exactly opposite from how you're seeing it.
I mean, why are we quibbling? There is a black and white judgment. Please read it. I believe I was told the speaker said it's only procedural irregularities. I think it sounds like Alice in Wonderland. Words will mean what I say they will mean. Does the speaker's decision declared illegal? Does the governor's decision declared illegal? A whip declared illegal? Vogable declared illegal? Sound to you like a procedural decision? Well, either you need education in law or you are Alice in Wonderland. And coming from a person who is exhibiting his premeditated bias, Speaker should never have got into it. It is showing a premeditated bias. The same applies to the Chief Minister. If he's saying that, he has either not read it or he's not been advised about it.
Dr. Singhvi, thanks very much for joining us. Thanks very much indeed. So that's, essentially one side of the arguments. I also spoke earlier on today to Mr. Mahesh Jethmalani, who believes that some of the points mentioned in the Supreme Court were points which he doesn't necessarily, and he respectfully disagrees with. Here's what he had to say about the developments in court today. Well, joining us now, Mr. Mahesh Jethmalani. Thanks very much for being with for being with us. Would you say that there is a moral victory for Uddhav Thackeray in all of this, that he may not be Chief Minister now, but had he actually gone to the Supreme Court at that stage and not stepped down, perhaps he would have found relief?
Well, I mean, certainly the matter would not have been as conclusive. I mean, it would have been hard fought. But in my view, the decision would still have gone in favor of Eknath Shinde had he not. But this was conclusive. After his voluntary resignation, I had said it on the day he resigned, the very night he resigned, that there was nothing left in the case anymore, because now this was an independent, discrete event, which not connected with anything that went before.
Mr. Jethmalani, the court has strongly censured the governor at that stage, Mr. Bhagat Singh Koshyari, for taking decisions that helped Mr. Shinde's faction. In fact, the court said that he had erred in concluding that Mr. Thackeray had lost the support of the majority of MLAs. Is this not, because there were quite a few references, is this not a strong set of references on the role of the governor?
But, frankly speaking, I don't know why one had to enter that, because he's a constitutional functionary, and it was not really necessary to decide the case. As you saw, the case ultimately turned on the fact that Mr. Uddhav Thackeray had voluntarily resigned. He didn't face that floor test which the governor, according to the court, wrongly decided to hold. But it's a matter of subjective satisfaction. I have to disagree on this point with the Supreme Court, very respectfully. I think there was enough material for the governor, right, to call for a floor test. There was sufficient evidence that the Uddhav Thackeray Uddhav Thackeray government had lost its majority, a fact which was not only subsequently established by the fact that Uddhav Thackeray refused to face the floor test, which the courts have repeatedly held, that when the Chief Minister refuses to face a floor test, it means it's an expression of lack of majority in the House.
Right.
And then the governor had no other choice but to call Mr. Shinde to form the government. Now, apart from that, if you look at the overwhelming numbers, one more point, Vishnu. Apart from that, Uddhav Thackeray lost by much more votes. The vote of confidence in favor of the Shinde government was by much more votes than even those members sought to be disqualified.
Yeah. No, I understand that.
So the governor's assessment was right. The court may feel that he didn't have enough material, but ultimately, in hindsight, Uddhav had lost his majority.
No, I take that point, but in terms of the decisions by the governor, a constitutional authority, and the propriety of the decisions taken, for example, what the Supreme Court said, and I quote, and this was very strong, the governor did not have any objective material and the exercise of discretion of the governor in this case was not in accordance with the law. Again, what does this say about the role of the governor?
Well, I mean, the court has made that finding, and frankly speaking, as I said again, I respectfully disagree with the Supreme Court. In my humble view, the governor did have enough evidence before him to call for a floor test. But 5 wise men sitting on the bench and 4 wise men and a woman sitting on the bench, right, have decided otherwise, and I have to bow to that verdict. But I can still critique the judgment.
Sure.
And on a television channel where you make only quick exchanges is not the place to do it. I will critique that part of the judgment at an appropriate time.
That's interesting. You will critique that part of the judgment. You feel that there was something wrong.
Yes, I think. I think one has to be fair to constitutional functionaries as well, no matter what. I mean, there are 2 sides to that aspect. Whether he had enough material. Remember, the court is making a judgment. It did not have enough. That the governor did not have enough material. Right? According to me, it did. Now there are the court has decided, and the Supreme Court is right because it's final. So we bow to it. Yeah? But that doesn't mean I can't express
by all means,
the Supreme Court a dissenting opinion.
And that's what we are talking about here.
Yes,
but just with regard to Mr. Koshyari, in fact, there's been a reaction which has come from him on this judgment, and he said, again, I quote, I am not a law student. I did what I thought was right at that time. What can I do when I have someone's resignation? So the other side of this is, if he has a resignation, he has to decide.
But exactly. Well, I mean, if the governor has to reach a subjective satisfaction, right? He can't be faulted for it. He may have made a mistake according to the Supreme Court. That's fine. But nobody should criticize the governor for taking a discretion, for exercising his discretion in a particular manner, because there was material. The Supreme Court may have felt there's not enough material.
Sure.
So there are 2 views to it. That's all right,
Let's look at the larger issue.
There can be nuances in this situation.
Got it. But Mr. Jethmalani, the larger issue is that the entire issue of disqualification has been sort of bumped down the road, as it were. I mean, there's been no decision on that at all. It's going to be now up to a larger set of judges to actually decide on that. That would essentially be irrelevant going forward, right? It would possibly send a strong message, but by the time it's all heard and a decision is taken, it may not necessarily have much of an impact on the ground. It's been too long.
No, the question of disqualification has been left to the discretion of the present speaker, right? With certain guidelines laid down by the Supreme Court. That is salutary. I mean, I think that's good. The speaker should know the limits of his discretion, right? So that's a good thing. As far as we are talking about the reference to a larger bench, it's about a particular aspect of when the speaker's disqualification, right, to judge on a case on the basis of the fact that his own majority is being challenged. That's a very limited issue. That has been referred to a larger bench. It won't affect.
As I understand it, Mr. Jethmalani, and correct me if I'm wrong, the power to decide on disqualifications will rest on the speaker until a larger panel of judges rules on it, is what the court seems to have said. So it would come up in court again in the future.
Yes.
All right. One final question.
Yes, this could come up in court in the future. But it can't affect this present case. The present disqualification will be by this speaker.
All right. All right, sir. Thanks very much for joining us. It's a very important judgment. Nothing changes on the ground fundamentally at the moment, but there's been a strong message from the Supreme Court. You can agree or disagree with it, but I think I mean that's quite clear that there is a strong message. Thanks very much for being with us. Thank you very much indeed.
Thank you.
Well, it is a huge win for the Arvind Kejriwal-led Aam Aadmi Party, with the Supreme Court making it clear that as far as this ongoing battle with the Lieutenant Governor or with the centre is concerned, the Aam Aadmi Party government in Delhi does have control over services. This is a battle which has been going on for many years and stems is the core or the heart of the disagreement, or some of the disagreements between the Delhi government and the centre, the control over services and resources, who actually controls them. For citizens on the ground in Delhi, it's often meant a great deal of confusion which agency actually deals with basic issues, whether it is looking after streets, whether it is looking after transport, whether it is actually looking after governance in so many ways in the national capital. Well, joining us now on this day, it's a very significant day for the Aam Aadmi Party, Raghav Chadha, the Aam Aadmi Party MP. Thanks, Raghav, very much for being with us. Let's look at the larger issue first, based on what the Supreme Court has said, which I think is this: in a democratic form of governance, the real power of administration must rest on the elected arm of the government. How does this observation strengthen not just the Delhi government, but our federal polity and the basic structure of our democracy?
Well, Vishnu, first of all, this is a landmark judgment. It's a historic judgment. And we at the Aam Aadmi Party wholeheartedly welcome this. We salute the Supreme Court for this big victory of Delhi, for this big victory of democracy, and I think it is a victory of Arvind Kejriwal and Aam Aadmi Party's perseverance for the last 8 years. Let's rewind back to the May of 2015 when this whole issue started, and that is when the differences of opinion and clashes between the elected government and the Lieutenant Governor's office started happening. It was in the month of May 2015 that a notification was issued by the central government taking away the services, that is the administrative power of Delhi, an administrative control over the officers of Delhi, and gave this power and this control to the Lieutenant Governor. And ever since that, over the last 8 years, you have seen that there has been a constant, this turf war between the elected wing of the government and the Lieutenant Governor. Today, the Supreme Court, in no uncertain terms, in an unequivocal manner, in a unanimous judgment, 5-0, has said that it is the elected government of Delhi that has complete control over the administrative machinery, has control over the officers, the transfer posting of the officers, the disciplinary proceedings against the officers, and the accountability of the officers is towards the elected government and not the Lieutenant Governor. And I think that is at the core of India's democracy. The hijacking of this administrative machinery by the central government's appointee, a parachuted, unelected person called the Lieutenant Governor, was anti-democratic from the first day. And it took us, unfortunately, 8 long years to get the pronouncement like this. But ultimately, quite frankly, finally, after hearing what the Supreme Court has said today, I can say this without any hesitation, that we can finally breathe. We feel that finally it's the people of Delhi and the elected representatives of Delhi that have won, and the BJP has lost. It's a big lesson for BJP also, Vishnu, that they should not try and disturb this fine balance of power that the constitution has provided between the center and the states, and also a lesson for them to understand that this regular sort of fetish to undermine elected governments is neither good for democracy nor good for the BJP's own politics, and that is what the Supreme Court has said today.
Raghav, this is actually one of the observations in the judgment. If an officer feels that they are insulated from the elected government, they feel that they are not accountable. You have the primary issue, and it's not just an issue which affects the Aam Aadmi Party, it's actually an issue which affects citizens like me. If there are officers or bureaucrats who do not function the way they are asked to function, then it's citizens who end up suffering, because without services you can't run one of the largest cities in the country. So this observation on officers and their accountability is important for me as a citizen.
Absolutely, and it is inconceivable, Vishnu, it is absolutely inconceivable that a government exists with no control, no functional or administrative control over the officers and the officials. I mean, a government cannot perform like this. A government or the set of ministers from the Chief Minister and his Council of Ministers function through these officers and the bureaucratic machinery. If this bureaucratic machinery is taken away from the elected government and they are told that, look, these people, the elected government will not, just cannot act against you. They can neither transfer you nor post you in a department, also cannot initiate disciplinary proceedings against you. You are not answerable to them, and we are insulating you from these people. The machinery will stop responding to the ministers and the Council of Ministers, and this essentially means that the democratic set of functioning or the constitutional scheme of governance in Delhi had to come to a grinding halt. But it is perhaps because of this constant struggle that the Aam Aadmi Party and the perseverance of Arvind Kejriwal that we've finally managed to get a judgment like this, where the Honorable Supreme Court has in no uncertain terms said that the elected government is the boss of Delhi. It is not the Lieutenant Governor, in a unanimous judgment.
With, of course, the rider that when it comes to land, when it comes to the police, law and order, and one more factor, those are in within the control or the ambit of the state. You don't have any grounds with that, right?
I'll tell you. Well, no, absolutely not. You see, when the Assembly of Delhi was constituted by virtue of insertion of Article 239AA in the Indian Constitution, it was envisaged that Delhi is going to be a union territory with a legislature.
Yes.
A unique kind of a setup. That means all powers will be with the government of Delhi except three. That is entry 1, 2 and 18. Land, law and order and police. We have never quarrelled or argued on this from day one. We have only said that barring these three subjects, that is entry 1, 2 and 18, that is land, law and order and police, everything else, including transfer posting of bureaucrats, including administrative and functional control over the bureaucratic machinery, has to be with the elected government. But it is in May 2015 that even this was snatched away from us by virtue of a notification. And in pre-Aam Aadmi Party days, when Mrs. Sheila Dikshit's government used to be running the administration in Delhi, they always had administrative and functional control over the bureaucratic machinery. They had no issues with that.
Happened.
It is only perhaps because of this,
right?
Because of the change in regime at the center, with BJP coming into power in the year 2014 with a thumping majority, that they snatched this power from us, and it was perhaps more to do with politics. But
let's hope, Raghav, at the end of the day, the battles that we see between the Aam Aadmi Party and the centre actually go away for citizens. That is important, but this is an important clarification and order now by the Supreme Court of India. The Mauritian equivalent of SEBI has said that it's not found any breach of law by the 38 global companies and 11 funds associated with the Adani Group in allegations raised by Hindenburg. Meanwhile, the Mauritian Financial Services Minister, Mahen Kumar Seratam, has told his country's parliament that the presence of shell companies on the island nation were false and that they were baseless. Joining us now from Port Louis, the Minister Mahen Kumar Seratam. Thank you very much, sir, for being with us. How do you respond, sir, to the allegations raised in the Hindenburg report on the alleged presence of entities in Mauritius that worked apparently as a conduit for money laundering and share price manipulation?
Well, thank you for giving me the opportunity to at least clarify the things that have been mentioned in that report to refer to. I've said it before and I say it again. Over the years, we have set up a very robust framework for global business activities in Mauritius. I must say our global business sector is well regulated today, and any licenses that are awarded by the Financial Services Commission, which is a regulator, as you mentioned, the equivalent of SEBI, has a duty to ensure that before any license is granted, conditions set in our legislations are being met. And one thing that I keep saying it, there's one element where we are intransigent is with regard to showing substance. What we mean by that is that any company, any entity in the global business sector being granted a license, they have to demonstrate that their core income generating activities is being carried out from Mauritius. So this is something which is imperative to demonstrate that. Over and above, it has to be managed by a management company. It has to have at least 2 local directors with, satisfying in terms of fit and proper qualities, and also in terms of caliber for assuming these responsibilities. And over and above that, they have to have bank accounts in Mauritius. They have to have their records kept in Mauritius. They have to have their accounts audited in Mauritius and filed in Mauritius. So there are a number of conditions that have to be satisfied before they get any license. So when the report mentioned about shell companies being harbored in Mauritius, that's why I said it's not true, it's baseless, and it's unfounded, and based on those requirements that entities have to adhere to. And I must say, as the regulator, they have to ensure that supervision is done on a regular basis, and at all times, those entities have to maintain that level of compliance.
Sure.
Today,
so let me ask you then, there has been a process of investigating these allegations in Mauritius. Could you tell us how robust that process has been?
A few years back, we were evaluated on our system here by the Financial Action Task Force, which is the organization that sets the standards with regard to AML CFT issues. With regard to technical compliance, there was no issue. And today, I must say, with regard to 40 recommendations set by the FATF, Mauritius is compliant, or largely compliant with all the 40 recommendations. To tell you that the level of compliance that we have reached, and those were assessed, reviewed by the experts from FATF, and we have demonstrated that level of compliance. This is the kind of certificate that we have today to demonstrate that our system is robust. So I don't think we can question the fact that those who set the standards have been wrong in their evaluation. That is why I keep saying it, to come and say things about our jurisdiction when we have demonstrated all the time that we are a jurisdiction of repute. We want to stay that way, and in fact, we have taken a commitment to sustain that level of compliance. And it's not only with AML CFT, I must say, it's also with regard to tax matters.
Yeah.
And there again, I must say, very often in the media, you see they refer Mauritius as a tax haven country. Totally false, totally incorrect.
I'll come to that allegation, and it has been raised in the past in a moment, but I'm just trying to understand, have you received compliance reports pertaining to entities linked to the Adani group, compliance reports on the basis of inquiries or questions which you have asked?
Of course, as a regulator, they have the duty to ensure that at all times their licensees are adhering to the conditions set for holding a license here. And I can tell you, the regulator has asked for those reports, and they have received it. And that is why I can tell you today that as far as Mauritius is concerned, as far as our legislations stipulate, there hasn't been any breach carried out by those companies that are licensed in Mauritius. So that is why I have no problem saying that in Parliament or anywhere else that those allegations are very baseless without looking at the way we work here.
And Minister, I interrupted you earlier on. You wanted to make the point that Mauritius is not an unregulated tax haven, that you have very stringent laws, and that, would you agree, Minister, that when allegations as serious as this are raised, it puts into question, the reputation of Mauritius in this field itself?
In 2018, we embarked in a major reform with regard to global tax matters. And we ensure that we adhere to all the requirements set by the OECD. As you know, the OECD is the institution that sets the standard with regard to whether a jurisdiction is practicing harmful tax regime or not. And I can tell you that we have been reviewed, our tax legislation has been reviewed by the experts from the OECD.
Yes.
And based on that, today, I can tell you that Mauritius does not practice any harmful tax practices. So we don't fall under that category as being a tax haven country.
Right.
We are whitelisted. And therefore, when some media refer to Mauritius as a tax haven, I find it very unhealthy and not fair to be treated as such when we are complying with all the requirements set by the OECD, which you will agree with me, is the institutions, international institutions, recognized for the setting of those standards with regard to tax matters.
Minister, are you contemplating or have you contemplated, has your country contemplated legal action against the Hindenburg Group for bringing disrepute onto your country in terms of the allegations which have been raised?
We're not discarding any action, but we are focusing on what we need. We think we need to focus on. There have been other papers being produced, reported in the past, and alleging this and that. But for us, what is important, I think, is the confidence that we need and the trust that we need to send, to convey to our people that we service, investors. And I'm sure those who are well-informed investors, they know, they have, those who have been working with Mauritius for years, they know the way things are done here, and they are the one, they won't base their decisions on reports such as the one that have been published recently. So, like I said, these kind of reports do cause certain harm.
Right.
But why we, as a jurisdiction, we need to, through your press, through your media, we're trying to reassure the business community, the investors community, that Mauritius is compliant with all those standards set, and we can reassure them that you can do business with Mauritius, and we don't allow any kind of unhealthy investments here.
Just to wrap this up, and it's a repeat of a question, but I just wanted to hear it from you one more time so that I'm clear on it. As far as Mauritius is concerned, the Adani group of companies have had false and baseless allegations leveled against them with regard to shell companies in Mauritius. Is that correct?
That's right. I keep saying it. All the companies that are licensed in Mauritius, they have to adhere to all the conditions set as per the Financial Services Act, which is a legislation governing those activities, and at all times they have to ensure that those conditions are being met.
Right.
And like I said, they are managed by local management companies that have to ensure and to provide compliance report whenever they are requested. And I can tell you that those are being met, and that is why I can say breaches have not occurred in Mauritius with regard to these companies that we are referring to.
Minister, it's been wonderful speaking to you, and thank you so much for talking to us. And perhaps in the future we can also talk about how close India and Mauritius, we are strategic partners, we are cultural partners, and we are people-to-people partners as well, which is the basis, I think, of our relationship. But it's been wonderful speaking to you this evening, sir. Thank you very much.
Delighted to talk to you. I must say,